opening sentence on regulation number 5 is taken into context and says, look, transitional regiments.
Opening sentence of
regulation number 5, the one that specifically talks about Mengo and Uganda Road. It states, on the publication of this statutory instrument in the Gazette, on the publication, then it goes on, all of civil matters which were previously filed and pending hearing under the Mengo Chief Magistrates Court, but originating from Central Division of Kampala, capital city, shall be transferred to Uganda Road Chief Magistrates Court. And all criminal matters which were previously filed and pending hearing under the Uganda Road Chief Magistrates Court, but originating from Rwanda Division of Kampala Central, shall be transferred to Mengo Chief Magistrates Court. Your Honor, the instrument is clear on publication, singling out two. It is silent on the other courts that we are proposed to be established. Your Honor, as I submit to you at this time, there is no officially opened and operational court at Karungu as a Chief Magistrates Court. It is our submission, Your Honor, therefore, that in interpreting this statutory instrument as to whether you have jurisdiction or not, you have to invoke the purposive approach. Could it have been the intention of the minister that while other places, particularly those ones previously covered by the Chief Magistrates Court of Masaka, as between the time of making the statutory instrument and when it is eventually operationalized for that area, that there will be no court covering those areas in Karungu district. That's the question that this court is supposed to inquire. Could it have been the intention in making this statutory instrument that the areas of Karungu not falling directly under Masaka after statutory instrument number 11 of 2024 would remain with no court? Your Honor, such an interpretation, if confirmed that it was the intention of the minister, would create a serious outside. Your Honor, there are a lot of authorities that a court would not interpret an act of parliament or an instrument that whose interpretation would eventually lead to an outside. And Your Honor, I'm well guided and fortified in my argument by the decision of the Constitutional Court in the consolidated petitions number 16 of 2013, of the Constitutional Court on the purposive Your Honor, Consolidated Constitutional Matters, number 16 of 2013, and 21.
Number
16 of 2013, 21 of 2013,
yes,
25 of 2013, and 25 of 2013. That is NRM, National Resistance Movement, as petitioner. Your Honor, I will start with the first one. That was, I will take the first one. That was by Honorable Kambasale, and others versus Attorney General and others. Your Honor, the crux of the argument put forward by my friend has resorted to resolution under the Interpretation Act. Section 10 thereof, Your Honor, under Section 10 of the Interpretation Act, which deals with appeals. And Your Honor, I want to quote verbatim: appeals and substitution. And Your Honor, that is under volume 1 of the laws of Uganda, where any act repeals wholly or partially, any enactment and it substitutes provisions for the enactment repealed, and it substitutes provisions for the enactment repealed, the repealed enactment shall remain in force until the substituted provisions come into force.
until
the substituted provisions come into force. You know, this particular provision of the Interpretation Act is premised on the purposive interpretation of acts and instruments. It's premised on the purposive interpretation
yes,
is premised on purposive interpretation of acts and instruments. That whilst there is a repeal ongoing, there shall be no vacuum. There shall be no vacuum in the legal establishment. There shall be no vacuum in the repealing enactment until the repealing instrument is fully operational and functional. Your Honor, it is my submission, therefore, that when a chief magistrate's court is created by an instrument, but the creating instrument is not yet operational and function.
The chief magistrate court is
created by an instrument but the created court in substitution and replacement, of the original court is not fully operational and functional. The existing court whose jurisdiction is intended to be taken away by the enactment, the existing court whose jurisdiction is intended to be taken away by the enactment continues in existence and in full exercise. Continues in existence and in full exercise of its general jurisdiction, of its original jurisdiction, of its general jurisdiction, with the unfettered powers and jurisdiction, with the unfettered powers and jurisdiction to receive new cases, hear and determine them, until the new court is officially, I will emphasize officially, until the new court is officially activated, whereafter there could be potential transfer. Of cases falling under the jurisdiction of now the new created and operationalized court. I do submit further that the jurisdiction of Masaka Chief Magistrate's Court legally was not and is not terminated and or suspended by reason of a certain instrument, creating the Chief Magistrate's Court of Ssewungu, which is not officially established and open to the public, which has no registry, and which has no presiding chief magistrate, And Your Honor, I will submit further that the continuity of jurisdiction by this court, the continuity of jurisdiction by this court, the continuity of jurisdiction by this court is constitutionally mandated, to avoid an absurdity and a vacuum, in the administration of justice. And Your Honor, this is consistent with the provisions of Section 10 of the Interpretation Act. I also submit further, Your Honor. And contrary to the view held by my learned friend for the respondents, that jurisdiction of court is not automatically terminated. And Your Honor, I want to highlight automatic. Jurisdiction of court is not automatically terminated or suspended by reason of creation of a blind court. And Your Honor, I still want to underline planned. By reason of creation of a blind court. The jurisdiction of this court, Your Honor, continues and remains in full force until there is a formal commencement. And Your Honor, I will still highlight formal commencement. Until there is a formal commencement of the newly created court to take over from this court. Your Honor, my other friend submitted, and I think he was sarcastic, that this matter should have been filed in the Chief Magistrate's Court of Masaka, of Karungu, sitting at Masaka. I take that to have been sarcastic, Your Honor. Your Honor, for the following reasons. I'm going through Statute Instrument number 11 of 2024. I've not come across an established Chief Magistrate's Court of Karungu sitting at Masaka. I've not come across it. So you need to file a matter in a court that is not existing is graver and incurable. Is the proper legal norm. Your Honor, I will further submit that appears that my learned friends for the respondents have confused the two matters: creation of a court and the operationalization of a court. Your Honor, the two are different. When a court is created, it has to be operationalized. Your Honor, I'm yet to be guided as to when the Chief Magistrates Court of Ssewungu was officially opened and operationalized, if at all it has ever taken place. Your Honor, should not that be the position? Should that not be the position? The respondents cannot run away from the Grand Norm Interpretation Act on matters of interpretation. Your Honor, it's a constitutional right for every person to access justice in a fair and timely manner. If court were to interpret that the creation of court at Ssewungu terminates the jurisdiction of this honorable court, where would the constitutional right to access justice by the applicant before you would be placed if there is no court in Ssewungu? And this court will take a judicial notice of it. You know the powers of this court, of the officers of this court, the judicial officers in this court. Subsist until the Chief Magistrates Court of Ssewungu is created. And Your Honor, I find safe haven under section 17(1) and 5 of the Interpretation Act, again giving continuity to the officer to continue exercising powers, and section 21(c) of the Interpretation Act.
Repeat those sections.
Section 17, my Lord, Your Honor, if it is read interpreted in context, 17(1) and C, 17(1) and section 7, subsection 1 and subsection 5, Interpretation Act, and section 21, subsection C, of the Interpretation Act. Your Honor, the matter before you is a matter that relates to an election, a matter of great public concern, where not only the applicant, but also the people who voted him, where not only the applicant, but also the people who voted him, must have a venue where they can access justice. Must have a venue where they can access justice. Your Honor, I would still believe that Marian Friendly was sarcastic when he submitted that if there is no court in Ssewungu, you would rather not file. Your Honor, I take that as being sarcastic. Your Honor, that's not the intention of the legislature, that there should be a vacuum and the people should be left with nowhere to access justice. Your Honor, you were cited before. I had in general submitted on the 30th session for you. The case of Ssewungu, Moses, and Ssewungu, which was cited for you on jurisdiction, was very specific. Ssewungu, Moses, and Ssewungu, the issue of jurisdiction related to the chief magistrate who had jurisdiction abdicating his duty to a person who had no jurisdiction to conduct the recount. In the Ngoma Nyime and Winibyanyima, in the Ngoma Nyime and Winibyanyima, still cited for you. The issue of jurisdiction related to the chief magistrate, who made an order for recount, which he had powers to do if he was in context. Related to the chief magistrate who ordered for recount when the person who had been declared by the electoral commission was no longer a candidate. When he was no longer a candidate, but was a sitting member of parliament who had been gazetted. Your Honor, the law was and is still settled that an application of the nature that is before you, can, among others, only be entertained if the winning candidate has not been gazetted. That was the issue in the Ganyima case. Again, submission of what the summary in general, there existed a court that had jurisdiction, but the party had gone to Colombo court. It is different. There is nobody Colombo court in the case before you. The applicant is before the right court because there is no other existing court. There is no other existing and functioning court.
Bana mbadde nfulumyemuko mu kooti ngenda kuddayo ke dakika 3.
Because I'm being frustrated. I know I was thinking about it.
Ngenda kubanzirayo eddakiika 3.
Kiki ekitwanguddako?
Ngenda kubanzirayoko eddakiika 3. Salamu. Kiri kitya. Sooka olindeko tetusosoka kwogera bintu ebyo byakwaki. Sooka olindeko mufune egundi. Mugende ku live ebintu mubirabire ku live. Nina byengenda otereeza. ompa magezi.
Zibwawo tetumanyi nawo gye bali, abalala bakwatiddwa bassizaako emisango. Ffe eno mbusire bwaffe wali abalala bwe bakutte babataddeko emisango simanyi badde batema kolansi naye nga okuva ekisubi gira paka Kasanje tewaliwo kolansi nga kolansi gwe baagabe babadde batema yabaddewa nga nfuufu njerere okuva Nate